fact situation he wanted us to talk about tonight.
This
So
is-
he's drawing us a diagram.
This is a convoluted deal. I'm gonna bring you into the end, and I'm gonna go back and give you a little history of
Okay.
how this thing
I'm gonna put
became
my glasses
so,
on so I can see.
so messed up. I got affiliated with my friend a few months ago, just shortly after he made his purchase, which was on May 26th. And shortly thereafter, I talked to him, and he showed me his paperwork, and he had not been to a title company. This paperwork was sloppy, poorly prepared. The settlement, the contract, everything was horrendous, and there were, I'll show you how it developed in terms of the mess that started the whole thing. But I said, Ron, you didn't go to a title company, you don't have a title policy? No, we just signed the papers in his office. Now, the people he bought this from have done hundreds of properties, so sort of shame on them for not at least offering him the opportunity to have the papers reviewed by his attorney, which I recommend everybody do. And the other thing is the title company.
What kind of property is it, residential, commercial?
No, this is a commercial property. It's probably a 1 acre or something on a high visibility location with a small building. It's used for a used car lot.
Okay.
So, to give you an idea of the structure, my friend and his wife are the purchasers of the property, and then the perpetrators were sort of training him on becoming into the used car business, and he formed an LLC to do that function. So the business is an LLC, the property is personally owned.
Okay.
And he bought it for $375. He spent his life savings. In fact, I loaned him some money on his house just before he sold it, and so that left $275 left. They constructed it into a first and a second lien. The first lien was $2,000 a month. Second lien was $20,000 a month. And this is where I feel.
And who are these notes payable to, Don? The people that sold the owner finance?
Payable, yeah. This was an owner finance deal from the previous ownership was a used car person by the husband, a used car LLC, and the wife was the owner through her LLC. So the wife owned the land, the husband had the business, gave the impression and even stated that he was getting out of the business, but one of the things that my friend did not get, and I gave him hell for this too, I said, you didn't get a non-compete or clause, and no, the guy's going out of the business. I said, no, I don't know about that. And sure enough, he didn't.
Yeah, the Yankees didn't get one from Nolan Ryan.
No.
I mean, no, not Nolan Ryan, Roger Clemens.
Okay, so anyway, we hashed over this fact, and I said, I'll go back and research the records, which I did, and I'll tell you a little bit about that. And as I did, I found lots of discrepancies and things, but when we went ahead and went to a title company and said, hey, we'd like to see what it would take to insure this little transaction that took place. They came back in August with Schedule C, 21 exceptions. Now, as recently as January, there were 17 exceptions still on it after we had bugged the heck out of them. And our position was, well, you haven't got clear title. Oh, yes, we got clear title. Well, how do you have clear title when you still got that kind of mess? So, I'm going to fast forward you, and then I'm going to take you back to the beginning. Fast forward is yesterday. He was foreclosed upon.
First Tuesday of February.
First Tuesday of February. And they did their
For violation of default under the second land?
default. Now, we brought it to their attention that there was all of these things that I'm gonna tell you about. And they gave my friend the impression on Thursday by phone call that, well, we don't wanna get into a legal battle. We're gonna look into this and we'll plan to stop the foreclosure. Well, then a day or two later, we got an email from somebody in the office saying that they're still looking into that. They would talk to us next week being this week. But they didn't talk to us, and we sent an email saying that we're relying on you not to do this foreclosure. We're expecting that you won't, but if you do, we seriously object. And my friend had prepared a couple of checks, but he insisted that if he'd take the checks, he stopped the foreclosure. Well, he didn't commit to that, he just didn't take the checks. And then you already know the end result. Now, as soon as, he gave us the impression he wasn't, but then, of course, we found out during the day yesterday that, yes, it had taken place, and not only that, he came by with a 3-day eviction notice. And so therein lies one of my questions. If you have a dispute on, in other words, he didn't want to pay not knowing what the debt really was and whether he would ever be able to get clear title. But, so if there's a dispute on the ownership and the title work, what are the consequences of remaining after the 3-day? It would be my impression that until they go down and file for a forcible detainer, you should stay and hold your ground, perhaps file a suit. That's where I'm looking for some direction.
All right, no matter,
Well, let me give you the rest of it for you.
well, can we just assume that what the rest of this means is that there were justifiably a bunch of exceptions on the Schedule C? That there was a real mess on the title?
My God, yes.
Okay, and if that's, we don't need the details to know that okay, so they didn't convey clear title in the deed. Was it conveyed to him by a special warranty deed
No.
or a general warranty deed?
No, well, it was conveyed by warranty deed with a vendor's lien.
Okay,
And the vendor's lien included deed of trust number 1 and deed of trust number 2, 175 at $2K a month.
right.
100 at $20K a month.
Okay, you say a warranty deed, do you know if it was a general warranty deed or a special warranty deed?
It said nothing about special, and so I took the implication that it was a general.
Okay, you gotta look at the granting clause to find out.
Yeah, well, I mean, I'll guarantee it didn't say anything about special.
Well, no, but okay,
The title normally says that, but you gotta look at the paragraph where it grants title and see who it's granting title through. And if it limits it just to the person that's granting the title, it's a special warranty deed.
the warranty language on the face of the deed, if it says, warranting title, as to claims by, through, or under grantor, but not otherwise, that makes it a special warranty. If it just says warranting all claims,
That's a general warranty.
then that's a general warranty.
Okay, now even.
So you gotta read it and find out what you got.
Even though this is another county, I've stayed up all night searching,
Right.
and I found deeds and deeds of trust and assumption deeds,
Right.
and deeds of trust to secure the assumption. And I've also found where there was a collateral assignment to a bank, and I mean, it's just,
Okay, well, and
all of that.
but I guess my initial response to all this is that regardless of the title that was behind in the past this transaction, you gotta look at on this transaction itself. Okay, you've got the warranty deed with vendor's land, you got 2 deed of trust. no question, your guy was in default on the second deed of trust, I mean, on the second
There's no
note.
question about that, but
And-
how do you convey something you don't have? And what I'm gonna tell you in a moment is all these things that you don't have, because there were judgments on various people along the way and companies that previously owned it, and they sold it without title policy, and.
Right,
it's
well, hence all the
conveyed-
exceptions on the
conveyed
Schedule C.
All, within all this. This is an LLC from the seller, and just to give you an idea, my friend purchased it on May 26th. He wasn't smart enough to know that you should go file the papers. The papers didn't get filed until July 31st
Oh my
by the seller, who filed his papers one document number later than this sale here. In other words, at the time he bought it, if you went down to the county clerk's office,
Jimmy owned it.
it wasn't owned by the people who were selling it to him. It was owned by somebody else.
Okay,
But
so, I mean,
they dummied this, well,
right,
they
so
got
here's,
this,
I mean,
so
here's
all
the
this was
thing,
filed at once.
here's the thing. Your associate may very well have a good lawsuit against the sellers for fraud in a real estate transaction, for breach of the warranty on the deed, depending on what kind of warranty it was.
Right, and I could pull that up.
And a number of other claims, maybe even deceptive trade practices. But, that would, the way to, my initial gut reaction is to attack the underlying sale to him rather than to attack the foreclosure directly.
Attack the chain of title?
No, and just, yeah, well, it's essentially attacking the chain of title. You argue that they didn't have good title to convey,
Right.
and therefore the whole deal was fraudulent or alternatively a mutual mistake maybe, and try and go for rescission as a remedy. See if you can get your money back.
The real problem they have is the 3-day notice to vacate. And the seller's gonna win that because they're gonna have apparent better title than your
Well,
guy.
I understand they're gonna win it, but should my friend stay there and wait till he gets the forcible detainer? Or should he, I'm saying he shouldn't leave now because that's abandoning the property.
Well, what he can do is stay there, even if he loses on the JP court level, he can appeal it to the county court. He'll have to pay rent while he does that, maybe post a bond.
Now, how would the rent be determined? Because
The
there's nothing to
JP court,
establish.
the JP will determine what a fair market value rent
Okay,
is,
fair rent.
and he'll have to pay it while it's on appeal, and he'll probably lose on appeal too. But in
Well,
the meantime, he can talk to a good real estate litigation lawyer. They may be able to enjoin the seller from going forward with the eviction. They can't enjoin the court from doing the eviction, and that's an exclusive remedy of the.
well, we can't get them to not go forward. They already have gone forward. But what, the outcome we would like to see.
No, with the eviction, not the
Oh, the
foreclosure.
eviction, okay. Well, actually, we're not really concerned about the eviction because we have another property rented that we're ready to go on. Actually has higher visibility, the overall deal is much better. So it's not a matter of not wanting to leave, it's a matter of if we leave, do we lose?
How does that look
do we-
in your
how's-
subsequent
how's it look-
lawsuit?
How's it look to the judge? Well, I thought you wanted to stay. You don't want to stay. So we don't want to confuse the system,
I
but
don't think you're gonna confuse the
Okay.
system. If
So
you've
would
got
you
a
leave
fraud-
or
If
stay?
you've got a fraud lawsuit, it's gonna be up in district court somewhere, and, it's
Yeah.
gonna be an after-effect litigation
well, but
fight.
now, these people are going for a deficiency judgment.
Yeah.
You see?
Right, and then,
and I-
and when they do that, are they doing that in, district court or county civil court of law? I mean, have they filed a lawsuit yet, or they just demanding?
I'm not sure of that. And now, the fact that, see, here's the deal. It was $375, and he paid $100, and down to here, and then he paid off, I think he's probably paid another $30,000 along the way. So if you,
Okay,
that would bring it to 270, so that would bring it down to about
250-ish, okay.
and, so they got the property back.
Well, you gotta look at the deed of trust to see if it had an anti-deficiency clause in it.
Probably not.
Oh,
And
this is all one-sided.
If it did not, then he's probably protected under Texas law, depending on the value of the property. But if it does have this anti-deficiency statute clause in it, then they can be liable for the deficiency.
To show you how sloppy the paperwork is, there's the two deeds of trust, and they're not the same. One of them kind of stops in the middle of everything and then goes to the last page, which signatures at the very top don't say who they are, of course, they're the buyer. But the other one has another page that goes down and it says blah, 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 as follows. Now, as follows, there's nothing that follows except the next page, which is the signatures, and it's just a mess.
Okay. Well, and there are, certainly, yeah, there can be issues about the enforceability of the deed of trust, but, I mean, it sounds to me like what your guy wants is to get his money back, not to get the property. Because the property is just a mess a title mess, that it's gonna be very expensive and time consuming.
Actually, priority number one is not having any further liability to this wonderful guy that sold it to him. If he could get
Sure.
out, that would be priority number two. Now, if in fact he could get some money back, that's great. But he's ahead of the game. Leasing this other property is more favorable to going ahead and paying another $250,000, which it really wasn't worth that. Even if he hadn't paid the 100, it wouldn't be worth $250.
Okay, well, so, all right, so,
Well, he may, if he's got liability, Don.
That's the thing, we want to make sure he doesn't have liability for the
I
deficiency.
can't, without any, he needs a lawyer to look at the paperwork, but if he has potential liability, then he needs to get an appraisal of the property right now, so that it's close to being appraised at the time it was foreclosed,
Yeah.
and defending that deficiency lawsuit.
yeah, I mean, you can get a retroactive appraisal.
Yeah, but it's better to do it now.
But if you can do it now, but I will say that whether he disputes the sale, the initial sale to him as a counterclaim in a deficiency suit, or whether he brings his claim first, to say the whole deal was fraudulent and to set it aside. Maybe he brings that suit first. That's a strategic call that would require a very detailed look at a lot of things, including, yeah, which county we're in and which judge we're likely to end up in front of. And do we want to control that by filing first?
David,
Yeah.
what kind of budget does this guy need to think about that kind of lawsuit?
That's the
He may
thing,
have
he spent all of his life savings.
Yeah,
Right.
He's gonna have a hard time finding a lawyer.
He's out of money.
That's a good
We
point.
don't want him to spend good money for bad. If the deficiency will go away, say la vie.
Well, but if it doesn't,
If
you
it
know,
doesn't.
he may have to spend it.
But let me ask you, just the fact that these people foreclosed and either the sale price, the sale price is less than the payoff, that creates a deficiency. So can they automatically file a deficiency in the records, or do they have to go before a judge to get that?
Oh, they have to file a lawsuit to get a deficiency.
Yeah.
Yeah,
get a
they have to sue the people.
The fact that there was a shortage, that doesn't give you anything to put in the public records?
Yes, it can, from this point of view. If they don't want to pursue it, they can send the guy a 1099.
Well, as
Yeah.
Isn't that right, Michael Platts? And that can be even worse, because now you're dealing with IRS.
Yeah, but as vindictive as this guy is, he wouldn't do that. It's only things that are for him. It has to favor him for him to do anything.
Well, this is an illustration
Yeah.
of, and Don's a very experienced person. He's had his share of courtroom appearances on things, and he knows it's nothing but a loser over there, money-wise, for the person that's involved in the litigation,
Sure.
in most cases. It takes a long time.
I mean, yeah, there are lots of cases you can
And
win
it takes a
and still
toll
lose.
mentally and physically on people. It's a rough thing to do.
Yeah, well, you remember the one I was in for 7 years?
Yes, I do.
Oh, God.
Yes, I do. Yes, I do.
And, yeah, and they do go on for years, and they can be very expensive, and they take a lot of your time that could be spent doing better things. And at the end of the day, yeah, you might get a judgment you can't collect, you might get, or you might get a judgment that's much smaller than what you spent to get it.
Or you might lose.
Or you might lose, and not get any judgment at all, or get an adverse judgment against you,
That's-
where you've gotta pay the other side.
What's he got to lose right now, $130,000?
Right
Well,
now.
he's already
right now-
spent-
right
He's
now,
already lost everything.
That's what he's out.
Well, he may be just as well the market work experience and go run that new car.
Exactly.
Make money.
If he's only out the 130 and he loses the property, that's not so big a
Well-
deal. But if there's a deficiency judgment of up to 250 for his future earnings,
Where is this property at?
it's up in Angelina County.
Do you know what they bid on the sale?
No, I do not. I
So
don't-
you don't know if there was a deficiency or
I'm-
not?
I'm seriously doubtful there was any bid at all.
Well, there had to be a bid of at least $1. Otherwise, there's no
If-
sale.
If somebody else took it. Otherwise, the previous owner converted his lien to ownership.
Well,
No, that's not how it works.
Oh, okay.
No, when an owner goes to foreclose, every lender, what they do is they calculate how much is owed on the note. And then they give instructions to the person that's foreclosing.
Oh,
They get to credit bid their loan. So if your friend was owed $250,000, they could have credit bid $150,000 to buy the property, and that would leave $100,000 deficiency,
Right.
okay? Or they could have bid $250,000, and that leaves no deficiency.
Well, let me say this, when he came by and gloated that, hey, I just foreclosed on you, I avoided your phone calls for all these days and let you think I was not going to, but I did. He said, here's your 3-day notice, and he proclaimed a deficiency, something in excess of 100.
Okay,
So I don't know exactly what it is, but
Yeah.
we're looking toward something over 100 as a deficiency.
yeah,
well, and, yeah, the other thing is that if it's a small deficiency, most lending institutions won't bother to pursue it, because,
Right.
you know, it'll cost them more money to get a deficiency judgment that they'd never be able to collect,
They
because
might give a 1099, go about their way, or they might do nothing.
they're more likely just do nothing.
Okay.
But yeah, you run into a vindictive individual like this, or a scam artist, and they're much more of a wild card.
Yeah.
It's much harder to predict what they'll do. But I would say if the deficiency is $100,000 or more, even a lending institution would look hard before walking away from that. They're more likely, the bigger the deficiency, the more likely they are to pursue it.
One of the things you pointed out just a moment ago, I seriously doubt, if you had a true appraisal, I doubt if it would come in more than 175.
yeah.
Well, unfortunately, the deficiency issue is pretty much
Based
going
on
to
the
be
note.
determined by the note and the deed of trust, but there is there are arguments to be made challenging the foreclosure sale as not having been properly conducted if the bid comes in substantially less. I don't know, is that just residential, or can you do that in
No,
commercial?
that goes, that law is not even really applicable.
On one hand,
Okay.
how can he say, a few months ago it was worth 375, but yet now it's only worth 150 or whatever?
That was just his owner opinion.
Yeah.
I mean,
That's why I'm saying if,
again, the actual appraised value it might only be tangentially relevant.
well, and if he sues on a deficiency, as David said, he may have to countersue. And that may be where these defective and deficient documents may come into effect, that, you know, they wrongfully foreclosed their interest on this, that they didn't have a valid lien on the property.
Well, here's what we would like to consider. We'd like to consider going before a judge and saying, hey,
Yeah.
we'd like you to set aside this foreclosure because of all this crap over
Right.
here, and we'd like to just give the property back, we'll deed it back, and we'd like to rescind the sale.
You know, that's not gonna happen without him paying a big ticket item to a lawyer.
I mean, that's,
True.
yeah.
I mean, it's gonna be tens of thousands, if not over $100,000 on a lawsuit like this.
Yeah, a lawsuit like that is gonna be very expensive, but yeah, it's gonna take a judgment for fraud or something like that to get rescission as a remedy, and rescission is exactly what we're talking about. We're just gonna undo the deal, he gets his 130 back, they get the property back, and everybody goes home with what they started with. But that doesn't happen without first spending a lot of money.
Let me
to
give
get there.
you some potential reasons why this chain of title could be construed as not valid.
Well, I'm gonna stipulate.
Yeah, I mean.
I'll stipulate, that's a bad chain of title, without even looking at it. I'll take your word for it, and the number of exceptions on the Schedule C
Yeah.
from the title company, that convinces me right there.
Yeah.
It's a crappy chain of title, they didn't have good title to convey, and there's probably fraud in the transaction. Because, or at least a breach of their warranty of title. But that doesn't, Michael he had his eye on the ball, you gotta look at the practical, what does your guy actually need to do? And that is gonna depend in part on what they do. If they're gonna file a deficiency suit, then your guy's gonna wanna assert as counterclaims.
So does he still need to be standing on the ground saying, hey, I'm not giving up?
I agree with Michael, I don't think that's gonna be that important.
Okay.
That's not gonna be, there's no legal doctrine that says, once you've been foreclosed and you've got your 3-day notice to vacate, that you have to stick around or you give up rights.
Okay.
Yeah. I think that's fair.
Yeah.
I mean, he wants to make sure and keep that 3-day notice of vacate in his record so that he can wave that around.
For the record, Don, don't tell him we said this, given that this is our advice, because it's not, because we're not giving him any advice.
I understand.
Right, but I would,
Entertainment purposes.
That's right.
educational purposes.
Entertainment's
This-
gonna level down.
You know,
Yeah. Entertainment's fun.
you know, if somebody was trying to write a story about
Would a
this,
DA get involved in something like this?
Maybe.
The guy's a scumbag,
maybe.
maybe they want to get this.
If they got a record of this kind of behavior,
Yeah.
my experience though is that the DA typically doesn't get involved in anything where they see there's a potential civil remedy. And it's going to, it's difficult to get the DA to invest the time in unraveling these kinds of complex
not gonna do
commercial
it.
deals.
They're not gonna do it. What you gotta do is you gotta bring the whole case to them already developed from the civil side and hand it to them, and then they'll get around to it in 2 to 3 or 4 years
If you bug them enough.
if you bug them.
If these people.
Or if it's big enough, if it's millions of dollars, they'll take it.
Or if it got a
This-
lot of press, if it got a lot of
Yeah,
publicity.
That's right. This deal's not one of them.
It needs to inform the people around there and want to do business with this guy.
Yeah.
Some of these small towns, man,
Well,
that's.
That's
Yeah,
right.
yeah, I mean, if there's a local Better Business Bureau or Chamber of Commerce where you can, now, the problem there is you've gotta be careful not to make yourself liable for defamation.
Yeah.
And the DA up in Angelina County may be different than the Harris County DA's office, you know, they're just,
Yeah,
they got too many drug cases.
And I've always had the impression that a good attorney knows the law and a great attorney knows the judge. We may have that situation.
Well,
Well, certainly,
Well, there's a
certainly
better
you
chance of
want,
that in Angelina County.
right, you want a local attorney, for a case like this, somebody who does, ideally, it's the guy who has coffee with the judge every Wednesday morning down at the cafe. And, and somebody who maybe even plays golf with the judge occasionally.
How do you know that?
Well, sometimes you have to ask around. We had a case years ago, we got it transferred down to Hidalgo County, and there was a lot of money at stake. We paid $100,000 to hire local counsel down there, but we hired the attorney with the most political clout in the whole county, because that's what we needed. And, if nothing nothing illegal or dishonest, just every time there's an election, this guy, this attorney, local attorney, he hires a bunch of school buses to drive around the county and bring in voters to the polls down in South Texas. And he's got ice chests full of tamales and sodas and beer on those buses. And if you're a friend of his, if you're a candidate and you're a friend of his, you can ride on one of those buses and chat with the voters. And if you're not a friend of his, you can stand there at the polls and try to greet the voters as they get off the bus with their new best friend. That's, it's all perfectly legal, but you're the guy that rents those buses and sends them around the county. You're the guy with the clout. And that doesn't necessarily mean the judge is going to rule your way every time, but it does mean you guarantee yourself that the judge is going to hear your arguments. Judge isn't going to make up his mind until he's heard your arguments.
As Mike said, I've been to court a time or two. Sometimes I will look up a court and see what attorneys have won or lost in that court. And especially the opposition, has he been in front of that judge before, and what was his track record? And then I'm looking for an attorney who's been in that same court that has a good track record.
Right. And you can also, election contribution records are
Yeah.
public records. You can go down to the county clerk's office and see who's given the most money to a particular judge. That's not necessarily, this guy with the bus trick, he wasn't necessarily giving a lot of cash to those judges. He wouldn't necessarily show up on those campaign finance reports. But that, that didn't mean that somebody contributing $500 was gonna have more clout than him.
I was raised in a small rural area. My dad owned a building that the voting machines, and you were responsible for 20 votes, and you were responsible for 35, and he was responsible for, and they hauled him in there. And give him a drink. There was no liquor on election day. They give him a drink and had a little machine there showing what pulled the outfit.
Yeah.
Pull one of the coupon.
We were talking about whether to form an LLC.
And there was over, the election was over, just looking at the people coming in, didn't have to count the vote.
Yeah.
And there was a guy there writing down,
Mhm.
did you bring 15? You said you had 15, you only got 12 to get.
In this transaction here, they probably use some LLCs, right?
Well,
If there's litigation that gets involved, everybody in the LLCs and every
if I may,
person's gonna
let
get
me give you
sued.
just a little bit of the, back here it was owned by an individual, and that's where it started out good, back about 2008. And through an LLC that belonged to Linda, she got a deed and gave a deed of trust. Clean transaction. From there, it went down the toilet. She gave an assumption deed to Jimmy. Jimmy gave
An assumption deed.
an assumption
What is
deed.
that? Do you know? I don't even know. what
Yeah,
that
no, that's where Jimmy assumes her note.
Yeah, whatever she did, he's
is.
assuming.
Well, I know what an assumption deed of trust is, but I don't know what an assumption deed is.
Well,
I believe
it's labeled that way.
Yeah.
And
Okay.
then there's a deed of trust to secure the assumption, I think is the way it was worded. It's all strange,
Yeah.
right.
but it goes beyond that. I think this is the document right here, when she signed her, let's see. No, let me go forward. She sold it to Jimmy on an assumption deed, and then Jimmy sold it on an assumption deed to another LLC that was owned by the same lady. But in the meantime, this one went into forfeiture, and she signed one of the documents, instead of signing it by this company, she signed it by this company, but it was dead. So the documents are questionable. And then this transaction shows up 2 months later, after my friend bought it, that shows that she had this assumption deed with this deed of trust, and then his took place within a few days after that. some of the documents, there's no notary stamps.
Oh, well, that makes it hard to record them.
Not in
now-
Angelina
now,
County, apparently.
The notary's name was there, but there was no stamp.
Right, so it's not a sealed document, it's not, they have
Right.
not acknowledged.
Right.
There's several of those,
Yeah.
several of them.
Yeah.
Okay.
Oh, and look, there were judgments against this company, and of course, that passes down the chain of title since,
Well, if they attach before
yeah, it attached before
some
the
of these
sale.
transactions,
So,
right?
so there was a whole bunch of judgments
Yeah.
against this company that went defunct, but this guy took it over. And so we got unresolved judgments, so we got unknown debt, and we got notary stuff that doesn't exist, and people signing from companies that are not really even supposed to be signing, and then they're conveying it to my friend.
Yeah,
Right.
but you
So
don't know
this
what kind
is-
of conveyance it was.
I'll find out here shortly.
So this is an object lesson, kids, in why we want title insurance. You buy property, you get title insurance, because the title insurance company, A, has the expertise to spot these problems and solve them for you. And B, if they mess up, they've got the money to make it right. That's what title insurance does. If it turns out seller didn't own what seller purported to convey to you, and you've got a title insurance policy, then that's the title insurance company's problem. It's your problem too, but it's mostly the title insurance company's problem. That's why, and title insurance companies hate those kind of problems. That's why they check title before they close. So this is why you want to get title insurance, and anybody who tries to talk you into closing without a title policy is somebody you don't want to do business with. That's a good rule of thumb right there. Anybody who's, I mean, if somebody says, hey, if you want title insurance, that's great, I don't care, then that's fine. They're not trying to talk you out of it. But if they're trying to talk you out of it, oh, you don't need title insurance, we can do this a lot cheaper, that's just a waste of money. That's a bad sign, all right? Your best hope is that they really don't understand title insurance and they're just wrong.
Now, isn't it true that seldom do you get the title insurance, you don't get it at closing, it's a few months later in many cases.
Well, there's a commitment.
You get the commitment, but you don't get the insurance. And I
Right.
can give you an example of that. I was a seller at Sovereign Title Company, and as far as I knew, the deal was closed, everything signed off, but lo and behold, I got a lawsuit in the mail. The title company did not pay off the property taxes from the guy that conveyed it to me. They just kept the money. Even though it was on my settlement, everybody signed it, it was all there, they didn't send it in. Consequently, the county sued my buyer, or foreclosed, and my buyer sued me, and I go back to Sovereign Title, they're not there. Now, mind you, the same building, the same office, the same phone number, the same desk is still occupied, they're still doing business, but it's a different name. It took me a year before I got out of that.
Mm-hmm.
And even though
Yeah.
I had a title commitment,
Yeah.
I didn't have the title policy, and we had to get the Texas insurance people involved.
Yeah, I was gonna say, the Texas Department of Insurance would be very interested
Until they
in
got
that kind of thing.
involved, then that's when they started coming in.
Right.
You know, your transaction here you've been describing and drawing for us, it didn't matter what entity your friends used or didn't use,
No.
they were gonna lose their money with this guy.
Yeah.
Okay?
The only
Your
thing that could have done was
entities
stay out
your
of it.
entities cannot protect you from your own ignorance or from somebody defrauding you, okay? It's not your fault they defraud you, because that's the whole thing about fraud is you don't know it when it's happening. But no kind of entity would have protected them, their $130,000, unfortunately, in this transaction.
If you were to Google the adversary, you'll find the case of the stolen house. I haven't read all that yet.
Well,
So,
I mean, it's an unfortunate situation, but I'm gonna say, yeah, if your guy,
if he'd have gotten title insurance, all this stuff would have shown up and they would have
Right.
walked away.
Yeah, all that would have been cleared up.
If they didn't walk away and it wasn't cleared up, then it was their own fault, you know?
Yeah.
But these documents and
When they should.
these judgments and so on were pointed out on the title commitment.
Right.
I don't think the title company, I mean, my friend would have to spend thousands and thousands of dollars to get those cleared up, and he doesn't have control over a lot of things. You can't go back and sign somebody's signature for him.
right,
Right, the seller would have had to have cured those.
Yeah, and
Right.
the seller says, oh, it's a clear title.
yeah.
Yeah.
No, I had to do a friendly suit for a woman a few years ago. Her father had purchased property with a quitclaim deed in the chain of title. And most title insurers won't insure title if there's a quitclaim deed in the chain of title. So if you use a quitclaim deed because you find it online and it looks simple and I can do this without having to pay an attorney, you're probably damaging your property value right there, just by using a quitclaim deed. Because all of a sudden, if you can't get title insurance, then nobody who needs traditional financing can buy your property. Because those lenders are all gonna require title insurance, right? So this woman, we had to file a friendly lawsuit, post notices in the paper, pay to have these notices published in the paper to any unknown claimants on this land. And after we ran 4 of those notices, then my client, in addition to paying me to represent her in all this and walk her through all this, we had to pay an attorney ad litem, one of the judge's buddies appointed by the judge, to represent the interests of these unknown claimants and do his own digging to look and see. And she ended up having to pay him, in addition to me, we had to go down there and actually conduct a trial. Now that trial, because we never found any of these other potential claimants, the trial only took about an hour. And we were done, but by the time it was all said and done, it cost my client about $15,000. Paying the ad litem and all the court costs and the publication fees, and my fees, just to clear up the title issue created by having a quitclaim in the deed, in the chain of title.
So she couldn't sell her house, or?
Oh, she could have, but she'd have had to sell it to an investor who would have only bought it at a discount, knowing they had this title problem to clean up. And then the
Right.
investor has to go, somebody has to at some point clean that up in order to get maximum value for
So
the
the
property.
investor will have to do whatever they.
Right, the investor would have been the one to hire me if she hadn't paid.
So if we are the buyers and if I want to buy a house and they bought a house with it's a quick,
A quitclaim deed.
quick claim, so I shouldn't buy the property because it's going to be.
Not unless the title company is willing to insure title. That's my point, is that was a case where with the quitclaim deed, you couldn't get the title insurance. So you go to the title company every time, and they'll tell you things like, oh, we won't insure title because there's a quitclaim deed. We won't insure title because there's a mess back here.
Right.
We won't insure title for whatever reason. That tells you, seller can't convey to you clean title, don't do the deal, don't close. Now, under your standard TREC form contracts, you have a limited amount of time after you get the title commitment and the survey to object or back out of the contract if you see something you don't like in the title commitment and then you don't think can be fixed.
I had a situation today presented to me, old man, and his wife. She's about to die. The daughter, who lives in Florida, is a lawyer, gets mom to sign a quitclaim to dad, and mom dies. And now they want to sell the house.
So they go to the title company says, not good enough, can't do it. The only good thing is, they don't have to do what you did, but what they do have to do, if, I think, I understand she had a will, they gotta go probate her will, who left it to her husband to cure that title. That's a simple solution in that.
Right.
But that's a lucky fact situation. Usually you have the fact situation where, you know,
You
it
can't
was
find
20
the
years
people.
ago when the quitclaim was done, and
the people who could fix it are dead now.
that's right.
So there's nobody to sign a correction deed. Believe me, yeah, that was my first question, was can we find the woman who signed the quitclaim deed and just get her to sign a better deed? Well, no, she's dead now.
Oh.
And so that's, because, yeah, that would have been a much cheaper fix for my client, a few $100 instead of 15,000. But yeah, you know, the further back that quitclaim deed is in the chain of title, the harder it is to do the simple fix.
Yeah.
No, that's a good point, though. They can be simple fixes.
You know, you'll find in a lot of these real estate courses, or you'll hear a real estate investor, oh, just quit claim an interest in it. Just don't ever accept or use a quit claim. I guess you could
Please.
use one and give it to somebody. I mean, I can give you a quit claim right now to the Empire State Building, that's good.
Yeah.
Because all it says is, I'm giving you whatever interest I have in the Empire State Building. That's all it says.
Whether he owns an interest in
Whether
the
I have
Empire
any
State
interest or
Building
not, whatever I've got, you get. So if I have zero,
You know, I'll give you $1 for your interest in the
Okay.
Empire State Building.
so that's what a quit claim, and quit is Quitclaim, quit claim. Now, he calls it a quit claim deed. When I went to law school, I understood it's just called a quit claim, not a deed, because a deed implies there's some sort of conveyance of title, and there is no conveyance of title at all with a quit claim. So that's the way I learned it.
Yeah.
But it's used, it's always called a quit claim deed, but it's not really a deed.
Would you prefer some title companies over other title companies?
Oh, I think,
Not sovereign.
I think that's a good question to ask anybody. I mean, if you've got people who do a good job in their,
A well-known title company, and the guy says anything over $1 million always ends up there, here in Houston.
Well, okay. There are, I mean, the fact is, title companies are all regulated by the State Board of Insurance, or the Texas Department of Insurance, whatever it's called these days. And the forms, the insurance forms, the policies that they actually issue are all on state promulgated forms. They can't, they're all gonna give you the same coverage. So all you're looking for is it a financially sound institution? And then what kind of service am I going to get from the local office? Are they gonna give me good service? That's really it. That's really the only difference.
and what they charge for escrow fees. And what
Yeah,
they
and
charge
then-
for deeds.
There can be, yeah, to the extent that they're auxiliary services, yeah, preparing deeds,
prefer
escrow
big
services, you
Yeah.
know, they do have more latitude there.
They-
But even the premiums that they charge for the insurance policies are all determined by the state.
Yeah,
So that's all gonna be the same.
it's gotta be a wonderful business.
And well-known companies, because you want to have a company that is going to be, you know, for years in the business, because
Yeah.
they close, some small title company close, and
We've hit our time, but we're gonna, Don, you had your question up.
Yeah,
You'll be the last one.
I've got another consideration that I'm sure we never thought of. We sent in the money, the contract completed, the papers were signed, but it was a sale from an IRA to an individual. The title company, even after the documents are signed, they insisted, well, a retirement account cannot own property, and therefore they wanted the individual owner of the IRA to sign the papers, but they're not allowed to do that. The IRA owner can only read and approve, and it's the executives of the
Right.
IRA custodian that has to do that. Well, this title company takes exception to that, says, no, they can't own it. I sent in a list of 164 people in Houston whose IRAs own it, and it's like $150 million worth of real estate. I said, well, how does this come about? But they still have the money sitting in their account. This is about 3 months later.
Have you talked to another title company about trying to finish the closing and get the money from
Well,
them?
we gotta pull the contract, take everything out, get the
Right.
money wired back and wired in, and
Right.
I think we're about to lose the whole deal because, I mean,
And
I know.
I don't know what the underwriters are thinking, but I'd make sure that you went to a different title company that used a different underwriter, that's for
the
sure.
owner of the company is taking a hard position.
Well, they can.
Well, no, let me ask you on that. Is it a fee attorney or the owner of the local title branch that's telling you, that's making this call? Or is it the underwriter for the title company making this call?
We get the impression it's the owner of the title company.
All right, if you can, because it sounds like, I mean, you can't make him do business with you, but it sounds like if you could reach past him to the underwriter for the insurance company, maybe the underwriter could set him straight. Maybe he'd listen to the underwriter. So perhaps if you could encourage him to contact his underwriter, instead of asking him to listen to you and what you have to say
Yeah,
about
well,
IRA
We've
ownership.
done that.
Okay.
They seem to have put their heads together and come up with this stupid idea.
Well, then then all you
gotta
can't
move
fix
title
stupid.
The gal's name is Rachel.
Okay, well, thank you everyone for coming tonight, we really appreciate it, and
Yep,
we'll see you in the next quarter, and hopefully Michael will be up here talking about tax issues.
instead of hanging out back there behind the camera.
I know.